guest now to discuss. Joining us this hour, national trial attorney Michael Jaafar. Michael, thank you so much for joining us. You know, for viewers who aren't accustomed to these kinds of hearings, nothing unusual happened. When there's evaluations of a criminal defendant, of course, the defense attorney gets an opportunity to have their own expert. Some of that was the nuts and bolts around all of that. But what do you think about the fact that at least at this point, the prosecution and defense are clearly speaking to one another? They're seeing what they can agree on as joint motions. They didn't yet have any discovery fights. I think it's a good place to start, but we don't always see it.
Yeah, this is usually how it goes in the beginning of these trials, because what happens when a trial starts, you got to look at it as like a collision, like a train wreck. Everybody's so anxious and so nervous when a trial begins. The prosecutor and the defense, any attorney who's ever tried a case will tell you, the day before a trial begins, they don't have any quality sleep. And while a trial is happening, they don't have any quality sleep. And when a trial ends, they look back and say, I missed at least 10 things, which is why in this juncture, right, everybody's nice to one another, everybody's cooperating, everybody's happy, and people are cooperating with one another, which is the way it should be, right? Case law has already determined that these people, litigants, have to cooperate with one another. They have to give each other information. Any single time in this juncture when I've seen litigants actually fight over discovery, it never ends well. It ends always poorly for everybody, right? So right now, typically, this is when everybody wants to get along, wants to talk to one another, and that's the way it should be.
Any shot at bond? They're scheduling a bond hearing here?
No way. It was difficult for me to say my remarks because I was watching that video and I was just stunned. So I was trying to stay focused on answering Judge Ashley's question because of that video. That video was disorienting. When I first heard that this had happened, an alert came up on my phone. I thought it was a meme. I thought it was a joke. You know, when I first became an attorney, you know, they checked me at the door before I went into the courtroom. I had to check my cell phone in, and then I went in there, and the judge was surrounded by 4 sheriffs armed to the teeth, and I was like, wow, he must really trust these people. So to think that this guy went in and shot the judge in that manner and went under it's like he was cleaning the room from how adamant he was to kill him. This is disorienting. You would have told me 20 years ago, one day this is going to happen, I would have told you you're crazy. It would never happen. So no shot at bond.
I don't know, though, Michael. There's a backstory, and I do wonder, to your point, Ted, if maybe during the bond hearing they bring in the motive to say this was specific towards this person. He's not a threat to anyone else, and he'll comply with conditions to be out of jail.
Yeah. I mean, it's an argument, right? And then they would have to divulge a little bit more, I think, of the motive of what happened with the daughter, you know, all that. But, Michael, that video, you're going to let this guy out? I mean, it's just too much. 3 different times he goes around to figure out a way to shoot him again and again.
And the judge has to make the decision, right? So the judge is going to look at this and say, he shot a judge in this way. I'm not going to let him out.
Yeah, that's a really good point. All right, Michael, stand by.
Attorney Michael Jaafar's with us. You add attorney's fees, you add the punitive damages. This could be very, very costly for CNN.
You're watching me sitting here envious of the attorneys who brought this case. My God, I'm so envious of that case. This is a really, really, really good day for trial attorneys, really good day. And at the end of the day, look, the $5 million is what they call just basic compensatory damages. That's just the judge's way of just the court's way of bringing him whole. This is different than punitive damages. For punitive damages, they have to show that the behavior was actually reckless, negligent, you know, kind of like nefarious conduct, outrageous, malicious, and so it's more serves as more of a deterrent for future conduct. And so in punitive damages awards against big companies like CNN, it could be huge. Maybe it might be $1, right? They might say that the conduct was not outrageous, was not malicious, was just an error. The court could find that, or if they find that it was egregious, you could talk about 100 million, you're talking about 2 million, same exact case, but the punitive damages are against, like, let's say a local paper. The punitive damage award is gonna be like $10 because they don't make money. But the same exact conduct against a company like CNN, that's why CNN goes through all these rigors to make sure, you know, they source a story. They want to make sure, because they're in the lion's den. Every single time they air a story, it's a 24-hour news network, right? So they're going to come in and tell the judge, listen, this is a 24-hour news network. We can make a mistake. It's not egregious. It's not malicious. We didn't intend it. Our facts were just wrong. We weren't trying to hurt this person. And that's how they get out of punitive damages. Because look, punitive damages bankrupt companies. I'm serious. they could be in the hundreds of millions of dollars. So we'll see what happens.
All right, Michael, so the jury has spoken, CNN liable. Watching that, do you think there's any opportunity that CNN might be in a position to say, let's now attempt to settle the punitive damages just to avoid the risk of a potential large award?
Absolutely, they will want to settle it to protect themselves. Their attorneys right now are in the closed room telling them, if we can settle, let's settle it. But do I believe that punitive damages are justified in this case? I do not. What he just said is correct, but that's what the $5 million is for. The $5 million is to bring him whole. Yes, he was lambasted. His face was publicized. All of those things are true, which is why he got an award of $5 million. There's a cost for the damages he got, and the cost was determined to be $5 million. 100 or 200 million, these are deterrent factors. These are for negligent, malicious, more than negligent, malicious, intentional conduct. I don't think they're going to be able to prove it. And that will be how the attorneys will negotiate with his attorney. His attorneys will lean on him and say, hey, listen, dude, we got you $5 million. We get you another $5. Or you could try your case in court and get $1. If we're going to take another $5, let's go ahead and settle it. He will absolutely be pressured to negotiate to take a settlement for the punitive damages. Absolutely.
Yeah, this was a story that was on Jake Tapper's Daily Show.
Yes.
But the correspondent, Alex Marquardt is his name, did it, and he testified in this case. And one of the, to get to your point that this wasn't malicious, one of the things that the attorneys brought in representing Young was the text messages that they got a hold of with Alex and his producers, and they got him on the stand, and the accusation was, you were after this dude. You did not like him. Let's take. So, Michael, to what extent is Alex Marquardt, his text, representative of the entity itself? So if I'm going to award punitive damages, if you're defending CNN, how do you make sure jurors can compartmentalize and to your point earlier that CNN is doing this 24/7, they have things instilled, they've got the road that looks at every script, they are fearful of exactly this, and they have things in place to prevent this from happening, and it just slipped through.
You could have 1,000 people working for your company, and one of them does something that you train this person not to do. You as an organization should not be responsible for. I hate myself for even defending organizations like that, because I'm the guy who would want to bring this suit, right? But you cannot control the actions, especially actions by an employee against your ethos as a company, right? So CNN will come into that punitive damages hearing, and they will come in and say, here's our ethos, here's our EOS guidelines, here's every single thing we have. This person, we fired this person went against our protocol, he sent an off-color text.
The problem is they didn't, Michael, they didn't fire him. And they told this jury with a straight face that, oh, black market doesn't mean black market. It means, and I think that was a mistake.
I agree with you.
To come in and say, there's nothing here, nothing here. If you're gonna not settle and you're gonna go to trial, you better put your big boy pants on and figure it out. Then figure out every possible scenario in the backdrop that a ton of people can't stand the media. They love court TV, I think. But the bottom line is that you get a juror or two or three or four who are coming in with a bias, who maybe hate CNN for other reasons. You're playing with fire.
You just literally said exactly what the attorneys are going to tell the CNN people to settle the punitive damage. Everything you just said is exactly what the CNN attorneys are going to tell their clients to say. We need to settle this case and get it out of your lap because you have egg on your face and the public could hate you. When you go in with a jury, you're going into a casino. That's what we tell our clients all the time. You're going in with a casino. You have this actual guaranteed thing right now, whatever, 10 million, 7 million. We could get rid of this right now. We could liquidate the risk right now, or we could go in there. You can have 250 million. Good luck on appeal. So you are going to see a settlement of the punitive damages. CNN does have egg on their face. At the end of the day, if the jury were robots, maybe CNN could get out of a punitive damages award, because this guy clearly was just a complete moron, and I think he should lose his job. But yeah, I think you're going to see a settlement of the punitive damages award piece just because of what you just said.
And I promise, if there's a settlement, there will be a non-disclosure so that no one gets to say how much that award was.
Yeah.
All right.
Yeah.
Still ahead. Stand by, Michael. We're going to check in on Tennessee and the Suitcase by the River murder trial. Some key testimony you might have missed in the trial for Jason Chin after the break. Still with us, National Trial Attorney Michael Jaafar. Michael, this is a hard case for me, watching all of the evidence against Jason Chin, and then hearing the defense explain that it was either heat of passion or perhaps self-defense. Now, there was glass. She had a glass, he says, and it was broken. But both of those things I'm having a hard time with in the face of all the evidence that the state is presenting against Jason Chin.
Mute.
Oh, yep, you're on mute, Michael.
Can you hear me?
Yes.
Yep.
Okay. These are the most difficult kind of cases that you give to a jury. We ask a lot of our juries every day all over the country. This is the most difficult part, right? Because the defense is going to come up there and say, look, he blacked out, right? He did this, so he blacked out. This was not premeditated. They want to reduce the severity of this. This is why the court had to bring in a jury from Nashville, because it was so grotesque, the fact pattern. So at the end of the day, the facts show that he just basically just completely eviscerated this young girl. Why did he do it? We're going to see some evidence. We're going to see at least one expert. We're going to see a lot of testimony. We're going to see a lot of the defense coming up there and trying to qualify why it happened. He didn't premeditate it. It was self-defense. It was a blackout. If they could convince the jury of this, obviously they would that would reduce the charges. But this is just so grotesque and so just egregious. It's a disgusting fact pattern. But this is going to be, if you're a jury and you're in the jury room after the defense is done, you've got a difficult decision. How do you know what the state of mind was? I mean, I don't think there's any evidence in this case that clearly points to a state of mind by this young man and why he did this completely grotesque amount of cut. If you did this to a squirrel, you would have sick. You'd be a mentally ill person. If you did it to an animal, if you did it to a cockroach, right? You do it to a human being, flesh and blood. I mean, I don't know. It's got to be tough for the jury to ferret through what they're going to hear coming up.
It's going to be tough for the defense to convince any human being that a broken glass found at the crime scene is the reason that this woman, a 100-pound woman, had a glass in her hand, and he, in self-defense, throws some handcuffs on her and stabs her 60 times, then puts her body in a suitcase. That doesn't sound like self-defense. That sounds insane, and it sounds like a guy that tortured and murdered a woman that he had a connection with that had gone away. And, you be careful what you do if you're the defense and you try to push the self-defense, because you're insulting people's intelligence. But we'll see, I guess, Michael. I mean, what do you think, by the way, of jurors asking questions?
I love it. I love when jurors ask questions. I'll be straight up with you on this. I think this should be like pervasive in our industry, because in our field, because you as a litigant, you want to get into a jury's mind. I always use the example of robots versus human beings, right? If it's robots, they don't need to ask questions. You're going to give them data and you want them to perform. Human beings, you want to know what they're thinking, because you as a defense attorney or a prosecutor, you lay awake at night, you wonder, how is this going to play off? How is this going to be interpreted? I want to say this, but I can't make a statement until my closing. I've got to ask questions. How did this come up? Did they understand what I was trying to get to by asking this witness and that witness? I love when there's questions. Then if you're confident in your case, you want the jury to ask questions. You don't want to wait until they give you a verdict and then you say, I wonder why they did it. You want to know exactly what they're thinking.
I love it too.
Yeah, it's immediate feedback.
Yes.
I mean, it's like, because here's what they're thinking, and you better adjust. Let's get a break. When we come back, jury selection beginning next week in a case out in California, the Celebrity Stylist Murder Trial. We'll get you caught up on the case against Monica Sementelli when we return. And big case Michael Jaafar's with us still. This is a problem for the defense. They're going to have to go against the credibility of the accomplice number 2, who is now also there. jurors are going to have to decide, do I believe the man, Baker, who says she had nothing to do with it, or this dude?
This is going to be by the way, so Ted, the state, the prosecutor hate this woman. They absolutely detest this woman. They believe she did it. They believe one over the other. And now they've been given this just hot potato of a case, right? Think about it. You're a prosecutor. You truly believe that Monica Cimentelli committed murder for the worst way, not defending herself, not because she was abused. She wanted money, more money. She already was enriched from her husband, her late husband. She wanted more money. You can see the prosecutor in every hearing seething with anger against Monica Cimentelli because she thinks she might get off the hook because all they have to do is prove reasonable doubt, right? That's all they have to prove, right? If you have robots, if you prove reasonable doubt, you're out. The state is going to have to argue to the jurors that, listen, don't believe the one who's saying that she didn't. Look at the pictures she's sending him when she's in jail. Look at the explicit text message. She's obviously an arch manipulator. She manipulated him before the murder. She's manipulating him since the murder, and don't let her off the hook. I think that this is going to be the most difficult case as a prosecutor to handle. I do not envy their task to prove their case. In this case, they're going to have to overcome some really overwhelming, inconvenient evidence, which is one of the co-conspirators is saying she had nothing to do with it. That's reasonable doubt if you look at just the letter of the law. So it's going to be very tough. They hate this woman, and I see why.
And that motive, that life insurance policy for more than $1 million, you always have a good motive with that the state will certainly continue to use against her. All right.